In today's video, we're going to discuss what easements and encroachments are, how they are created, and how we get rid of them once there's one that's been established. But there are a couple of things that we have to understand before we get into the specific types of easements. Let's take a look at them. Number one, they are created by people, they are created by operation of law, and they are created by use. Now, depending on which one of those create the easement determines what type of easement it is. Two other things to remember when we're talking about easements. Number one, they pass with title, meaning they pass with owners. So the new owners of that property, they are bound by the terms and the conditions of those easements. And the other part is for an easement to be enforceable, for it to be valid, it must be in writing according to the statute of frauds. Very important to remember for your real estate licensing exam. All right, so let's take a look at what an easement is. Well, an easement is simply the right of one person to use the land of another. The key here is the right to use. There's no right to occupy and there's no right of ownership. It's only a right to use. And again, how is an easement created? It was done by two people, maybe mutual consent, by an operation of law, or by continuous use. Now, a couple of key terms that you also need to know is what we call ingress and egress. Ingress and egress is just a fancy way of saying a person has a right to enter and to leave. Remember, they don't have a right to occupy. They can't enter and stay. It's just a right of ingress and egress. Okay, the first concept I want to discuss here is easement appurtenant. Now, easement appurtenant has two key players here. Very important to understand. It's called dominant tenant and servient tenant. So let me illustrate on the board what I'm talking about here. So let's say that we have two property owners. One is a dominant tenant and one is a servient tenant. So this owner is the dominant tenant, this is the servient tenant. Now, what that basically means is the dominant tenant has the rights over the servient tenant. It literally means the dominant tenant has the right to walk across the servient tenant's property. That's easement appurtenant. The dominant tenant has the right over the servient. The servient tenant serves the dominant tenant. Now remember, there's no ownership here. Only a right to use, the right of ingress and egress. The second type of easement I want to discuss is easement in gross. Now, an easement in gross means there is no dominant tenant. We see this a lot with utility easements, and here's what I mean. Let's say we have a piece of property here, and the property owner is the servient tenant. Remember, there is no dominant tenant, because the utility company wants to put a utility line across that person's property. The key here is there is no other piece of property for a dominant tenant to ingress and egress. But there is a need for the utility company to put in a power line here. All right, again, ownership or title does not pass. It's only a right to use. But the key with easement and gross is there is no dominant tenant. Now, the next type of easement I want to discuss is what's called an easement of necessity. And it sounds a lot like what it means. There is a necessary reason for the easement itself. So let's take a look here. Let's say that we have a property owner, and this is a highway. And there's no way for this property owner right here to access the real world. All right? This is what we call a landlocked property, a landlocked property. So this property owner A is going to get an easement to go across B's property so he or she has access to the highway. Easement of necessity. Now, very important that you remember with an easement of necessity, it is only established by a court order or mutual consent. So A and B could get together and say, yeah, we're going to agree to this easement. Or if B disagrees, then A would actually have to go to court and get a court order to force the easement. Now understand, A does not own this driveway here. It's only a right to use, to go to and from. And it would actually be trespassing if A, cruised their vehicle along the easement and stopped right there to watch the sunset, for example. That would actually be trespassing. An easement only allows for the right of ingress and egress. That is easement of necessity. Now, the last type of easement I want to discuss is what's called an easement by prescription. This is created by use. All right, easement by prescription is only created by use. So let's take a look at what I'm talking about here. So let's say that we have two property owners here, and they are side by side. And we have a highway here and a highway here. All right, Sally owns this property and Tom owns this one. And here is town. Tom works in town. So what Tom does every single day is, instead of, when he comes home from work, to and from work, instead of going all the way around to his driveway, what Tom does is there is a little access road right here. So Tom goes to work going across Sally's property, and then when he comes home from work, he uses that access road to get back. All right, that is what we call easement by prescription. But for easement by prescription to be valid, there are some key legal essential elements that must be met. Number one, Tom must have done this for a prescribed statutory period of time as determined by that specific state law. Number two, it must be open and notorious and in a hostile manner, meaning it has to be visible and actual and against the wishes or hostile to Sally, meaning Tom didn't ask Sally's permission to do it, he just did it. All right, so Sally would be recommended to go and put a do not trespass or a gate up or something that stops that continuous use for that prescribed statutory period of time. But if Sally didn't do anything to stop Tom from doing that after that prescribed statutory period of time was up, then Tom could actually go into court and say, hey, listen, I met all the essential elements and there is a prescription easement that has been created. Easement by prescription is through continuous use. Quite frankly, that's when, if you go out into the countryside, you see a lot of no trespassing, keep out signs. And one of the reasons that's done is certainly to keep people out, but to prevent anybody from creating those easements. That is an affirmative defense that the property owner can raise by having those keep out or no trespassing signs. Now, the last concept I want to discuss is what's an encroachment. Now, an encroachment is different than an easement. An easement is a right to use. It's the right of one person to use another person's property. An encroachment is actually very common in the real estate transactional world. So let me give you an example of what an encroachment is. So let's say that we have somebody's property line. We have Tom and we have Sally. But there's a fence. And the fence belongs to Tom, and it encroaches on Sally's property by 3 feet. That fence is what we call an encroachment. Another thing that's very common that we see is overhangs from buildings that's right on the property line, and it overhangs into the next person's property. Those are encroachments. So an encroachment is not a right to use. There's no easement developed. It's just somebody's property is encroaching on somebody else's. And in fact, Sally has to be careful because depending on the state law in the state that this property is located in, if this fence is here long enough, Tom could actually claim adverse possession, which has actually been done. It's not too uncommon. So it's very important that when we're putting up fences that we want to make sure that we do a survey so we know where that property line is to make sure that the fence isn't encroaching on our property, because there can be long-term consequences of that. All right, so how do we get rid of an encroachment? Well, Sally could simply tell Tom, hey Tom, move your fence. Or Sally could say, listen, I know that it's 3 foot onto my property. So when the fence needs to be replaced, please move it 3 feet over onto your property. Those are the common corrections that we see. Last thing I want to talk about in this video is how do we release or get rid of easements? And there are 5 ways that we can terminate an easement. Number one is mutual consent between the two property owners. They simply agree to terminate the easement. The second way is through a merger, meaning the merger of the two properties. Certainly if the two properties merge, there's no need for the easement anymore. Court order. A judge can terminate any contract or any easement. Number four is an abandonment. So one of the parties, particularly the dominant tenant, abandons their right to use that easement. And the last one is the need no longer exists, such as an easement by necessity.